started again. And I'd like to do the introductions of our speaker. If in the back row there, could we have some quiet? Thank you. Thank you very much. I'm Bob Goldman. I'm the faculty director of the War Crimes Research Office, and I teach here. And that's why I can tell people to be quiet as I do in the classroom. We have two really very qualified and distinguished individuals today. One who will be speaking and the other commenting. Both of them are distinguished because of what they've done in life work to combat impunity internationally, and also to bring about accountability for serious violations of the laws of war and or human rights law. Our speaker is David Tolbert. You have the complete bio of David. But he is presently the president of the International Center for Transitional Justice. He is the former Registrar of the Special Tribunal for Lebanon, former Deputy Chief Prosecutor of the ICTY, and he is also former Special Expert to the United Nations Secretary General on assistance to the Khmer Rouge trials. After David speaks for about 20 minutes or so, Juan Mendez will offer comments. Juan is a professor of human rights law here at the Washington College of Law. He's currently the United Nations Special Rapporteur on Torture and CID. He was a former special advisor to the Secretary General on the prevention of genocide. He is also a former member and former president of the American Commission on Human Rights, and the predecessor of David's as former president of the International Center for Transitional Justice. And I might say also that Juan was general counsel of Human Rights Watch, but perhaps even more importantly, Juan was the director of America's Watch in what I like to term its glorious years in the 1980s and so forth, where so much reporting was done. Indeed, speaking about in places like Guatemala, and did so much to expose violations. So, without further ado, David, it's yours.
Thanks, Bob, for that very kind introduction. And it's an honor to address all of you here today. Glad to be in the company of many good friends and colleagues. And I'm particularly pleased to be followed by Juan Mendez, predecessor at ICTJ, but even more so, Juan is one of the true giants in our field, as well as being a good friend. Is that better? Modern technology, okay. I'm also very glad to be back at the Washington College of Law at the invitation of my good friends at the War Crimes Research Office. Susanna and I have known each other for 10 years or so. She doesn't look any different. I obviously do. But I have long admired the work that the office has done under leadership, obviously under overall leadership, and really great work that we gather at times as well. And although it's not the subject of my talk today, it's good to be here with good friends in the wake of the Keynote judgment. It's a major achievement for accountability. And obviously, for the victims, a great day. They've been waiting for justice a very long time. And particularly given what I think is a very difficult environment for human rights and accountability, generally, accomplishment. In case he's watching by webcast, I doubt it, it's pretty late in The Hague tonight, but Alan Teeger deserves a great call out for the tremendous work that he did. If you're tweeting with Alan or whatever, let him know that I just said that. I don't know whether it be captured on tape or not, but he deserves it. In terms of my topic today, I will focus on the question of complementarity. It's already been discussed a good bit. Many of you have been working on or thinking about. I take this subject up really because I think complementarity is at the critical intersection in international and national. What I want to do is to try to avoid the platitudes that we hear about complementarity. Really try to focus on and discuss this important subject in an honest and critical light. To do so because I think if we take the issues around complementarity seriously, we need to approach the topic honestly and with rigor, really asking ourselves the hard question. From my point of view, there's been too much lip service paid to the idea of complementarity, not enough wrestling with the hard realities that domestic investigations and prosecutions are on the ground in very difficult circumstances. Well as, and many of my remarks will be about the very serious political case. It is, of course, really now axiomatic that we, and by that I guess I mean international community, are serious about criminal accountability, serious crimes. We look to our North Star, which is the Rome Statute. In principle, the drafters of the Rome Statute, and I think it right that the onus should be on state parties to investigate and prosecute. As I think we all recognize, the ICC statistically only play a role of the court. But that leaves many hard questions and much work for the rest. The initial question is whether the national authorities have the political will, technical ability to carry out these investigations. While admissibility questions are obviously important, the prime issue for us today concerns those crimes that are not addressed in the Hague. That's what I'm discussing today, as often stated already a number of times this morning, positive complementarity. That is how all of us, government, civil society, the ICC, Assembly of State Parties, supporters of accountability, help ensure that those who commit Rome Statute crimes are held to account. I think it's worth saying a few words about justice in the context of massive crimes before turning directly to the topic of making accountability work in practice. There are many experiences that are worth considering when we think about accountability for serious. In a wide range of situations, time has to pass before criminal accountability could occur on the national level. Argentina is a good example. Some of the most serious crimes that occurred in the junta period are now being prosecuted. Moreover, the road to prosecutions for serious crimes were made possible in Argentina by the groundbreaking Nunca Mas report of 1994, which was by CONADEP, an important commission. President Alfonsine. Similar points could be made in a variety of other countries. Chile, the important work of criminal justice largely followed the work of a truth commission. In Peru, years elapsed between the prosecution of Fujimori. One should also not forget the important and groundbreaking impetus provided by the Inter-American Commission in an array of important cases. Even if we look at the international level and the ICTY, Milosevic, or for that matter, Karadzic, were hardly the first prosecution, first fugitives brought to justice. It took many years to make the arrest of all these fugitives. Yes, I would really like to emphasize two interrelated points. The political situation matters deeply in terms of when a prosecution can happen, any level, and particularly on the national level. Moreover, justice does not only come in the form of prosecution. Truth commissions get at important issues that prosecutions cannot address. And much fuller telling you what happened in terms of human rights abuses, reparations programs, and I would include part of the work of the ICC Trust Fund, offer victims a form of reparative justice that can be powerful and important. Forms such as vetting and other steps help restore civic trust. Thus, we should not forget that prosecutions are a part of a larger set. Someone who has to be firmly in both transitional justice, national criminal justice. I think we must bear in mind these 2 points. Vulnerability in the context of a society that has experienced massive human rights abuses. These measures work together and are all forms of accountability. Thus, the sequencing of measures and approaches can be very important. And so in a number of instances, prosecutions may not be possible ab initio. Often must wait for political changes or it. Now to the question at hand, how can international actors assist in supporting domestic prosecution? Or in another formulation, how can they support positive complementarity on the ground? I look first to the Rome Statute, which contains the essential elements to be addressed. It provides that the ICC can only exercise its jurisdiction if the state party where the putative crimes have occurred are either unwilling or unable. And unfortunately, in many of the contexts that we're talking about both unwilling or unable. Unwilling and unable to investigate. Much of the discussion that you will have today and has happened this morning, and I think will address issues of vulnerability. This is understandable because the lessons learned from national or internationalized processes are much easier to articulate and to some extent utilize in terms of addressing vulnerability, capacity building, and technical assistance. Much easier to address than issues of political willingness, which are much more specific to the actual country involved and very difficult to generalize about. Despite the difficulty in addressing the political dimension or the issue of political will, I think the question begs to be put on the table. While the actual political blockages in terms of prosecutions of serious crimes will vary from place to place, I do want to offer some general thoughts on how these issues might be addressed. My first point of reference is that a serious analysis of the national political environment is called for before any effort to support national investigations and prosecutions commence. I think there is little purpose is served by putting technical resources into a context where without a clear understanding of the political dynamics. While there are some situations, Sudan comes to mind, where the authorities simply deny any type of or any form of accountability, or either an implicit or an explicit rejection of any responsibility for the crimes committed. Other situations are much less clear. The case initially in Libya, for example. In other international experiences, such as the ICTY, there were cases where lower-level accused were turned over to the tribunal or even tried in national courts in an effort to try to shield more senior commanders or political leaders. The latter approach is particularly difficult to parse, as it may have a veneer of credibility in some instances, due to the difficulty of proving direct culpability in leadership cases, as against a more straightforward case of individual soldiers or paramilitaries who directly commit the crimes or pull the trigger, so to speak. Thus, what may be presented as a proof problem may actually be an effort to shield more senior political or military officials. My experience at the ICTY in particular has taught me that good political intelligence on the country concerned complements and is an essential ingredient to complement a prosecutor's technical skills. These two things need to work together, or these two abilities need to work together. Thus, while some of the situations of mass abuse will fall into categories of complete denial or non-compliance of a state's Rome statute obligations, other situations are going to be much more complex. The question is then how, in these complex situations, can countries be encouraged, supported, or, pardon the expression, appropriately pressured to tackle these serious crimes. In this regard, the government itself may not be a monolith, and there may be a variety of approaches and motivations within the state or government itself that need to be parsed and understood. Now, some have suggested that the Assembly of State Parties could play a role in gardening and providing the political support to either pressure states to exert the necessary political will to act and or secure the necessary cooperation. In my view, such action by the Assembly of the State Parties would appear to be very unlikely, because there will be spoilers in the ASP that undermine even mild action in terms of statements of political support by the Assembly of Parties as a whole, much less more robust action. And in that regard, I think we just simply need to think of the Kenya situation. A more promising approach would be a coalition or grouping of states, preferably a diverse group of like-minded states. The like-minded states played a very important role in establishing the International Criminal Court. But a group of like-minded states that would work together to provide the political and material support for national prosecutions and cooperation. And there have been some discussions in this regard. And a number of states have played really important roles in pressing for accountability on the national level. I see Ambassador Rapp here, and I can't think of anybody who's more tireless in his efforts in this regard. I think if they have a quadruple platinum, Steve would definitely have it on the airline. There's very little evidence at this point that any particular formal grouping or even informal grouping of states will emerge to play that role of providing the pressure and support politically. It seems more likely that ad hoc groups of interested actors will support efforts for investigation and prosecutions in specific countries rather than a larger group. The Green Tree discussions, which I'll come and talk about, I'll come back to in a moment and discuss in more detail. We did have some indications that like-minded states might work together in a more coordinated fashion to provide support for national governments or national prosecutions in a sustained way. That seemed to wither on the vine. But one would hope, and I think it's important, that some kind of core group of supporters, or at least ad hoc coalitions, help supply the political and material support, and that a group like this emerge at some point. As these issues need more sustained and coordinated approach and support for the process. As we think about these questions of political will, we need to be aware that while international actors have a role to play, they cannot obviously be a complete substitute for national willingness to address accountability. And in this connection, I do think we need to think twice about what roles international actors play and make sure that we, first of all, do not make the situation worse. We need to be careful of empty gestures. I think now the U.S. Congress's recent call for an ad hoc tribunal for Syria, which has zero possibility of being adopted. Empty gestures can be counterproductive. They potentially give victims false hope and also can expend political capital that would be spent in more effective ways. In a related but somewhat different vein, One cannot help but reflect on the Special Tribunal for Lebanon and the extraordinary chambers in Cambodia experiences, which I confess I had involvement in both. In the case of the STL, the very narrow mandate of the tribunal, which aimed at one particular assassination in certain connected cases, in a country where there were many, many assassinations. The manner in which the STL was established by the UN Security Council and the political milieu in Lebanon. I think it is understandable how the STL was considered by many to be at best one-sided justice, and by others as a politicalization of justice. While I think the latter characterization is not fair, nonetheless, the STL was widely perceived this way by a significant portion of the Lebanese population and beyond. And unfortunately, the results have been, for these reasons that I've noted and others, quite limited thus far. The rather tortured history of the extraordinary chambers in Cambodia is quite different, but it does show the difficulties of making compromises that make delivery of justice very difficult and protracted in the extreme. I think there's a case to be made for the work of the extraordinary chambers. They've done some important work, particularly the conviction of the former head of state and of brother number 2. These are significant milestones. Nonetheless, the price tag has been a high one, and the extraordinary chambers model should be avoided at all costs. Along the same lines, we should also be wary about hybrid tribunals being considered in the midst of conflict or where the political circumstances are too adverse. We must bear in mind that our first order of business is not to make the situation worse. A failed hybrid tribunal or a process that is highly politicized may do more harm than good on the long term and make it less possible for successful investigations and prosecutions to occur in the future. As I mentioned, the first step towards accountability may not necessarily be a tribunal. I think it's important to underline that all transitional justice measures need documentation, evidence, and relevant materials. And much good work can be done in this area. For example, there are several groups working on Syria who are doing important work in this regard. Also, preparations can be made in terms of building the knowledge of these processes in national civil society groups, which at the end of the day are really the demand side of justice, and including particularly the diaspora communities. In this connection, it's worth underlining the particularly difficult circumstances that are faced when conflict is being brought to an end by negotiation on the so-called peace and justice question. I don't think we should be naive on this front. Issues in negotiating an end to a conflict are fraught with challenges. And the difficulty of securing a peace agreement and providing for justice is quite real. I don't think the platitudes about peace and justice being indispensable to each other, and I stand guilty of saying this myself. While it's true that they are indispensable to each other, there's the real world of negotiation. And these kind of statements, I don't think, help us advance the ball. In my view, we really need to tackle these questions seriously and creatively. My colleague Henry addressed some of the discussion about Colombia and the negotiations in Colombia earlier today. I'm sorry for those of you who missed that. I thought that was a very interesting and powerful discussion. And particularly, although we didn't have time to discuss it in much detail, the questions around the special jurisdiction for peace. There are a number of questions that remain regarding the agreement between the FARC and the Colombian government, and particularly its provisions related to justice. I think that the proverbial devil is in the details holds true here, so I think we have to see how we have to see how the agreement actually works in practice. There are a lot of questions. I know that many, or a number of people are critical of the agreement, a number of groups are critical of the agreement. I think some of the underpinnings of the agreement are fairly straightforward, but particularly in the matter of penalties and how sentences are served, these are areas of considerable debate. And I think we should welcome this debate. These are some of the toughest issues in our field, and we should wrestle with them honestly and forthrightly, and I think get out of our comfort zones from time to time. I want to turn briefly to the questions regarding inability, and I'll refrain from only making a few comments on that, given a very few comments on that. You do have a lot of excellent experts here at hand, and there's been a good bit of discussion of this already this morning. I did want to mention and outline briefly some of the discussions that we had at the Green Tree Estates for the Green Tree discussions, which were at the Green Tree Estate, since, and therefore the name. There were 4 major international meetings, also meetings in Cote d'Ivoire and the DRC, looking and drawing lessons on how to support domestic prosecution efforts, particularly on questions of addressing issues of capacity to conduct investigation and trials for Rome Statute crimes. And I think one of the key findings of this, of our studies, or of our discussions, was that a thorough assessment of the national system on a range of issues was very important. And we pointed to the experience of the Bosnia State Court in particular, where, which was discussed by Judge Whalen this morning. The assessment was conducted through a number of joint working groups of national and international authorities. I think Judge Whalen made an important point that the national participants did not get sufficient credit for their involvement of the design of the court or their participation in the court. I think that's an important point to underline. In any event, this assessment looked at such issues as witness protection, detention in prison facilities, defense issues, and prosecutorial strategies. And this assessment, I think, was very important in amending the laws properly, establishing a new institution, new judicial institutions, a new code of criminal conduct, training for judges, training for prosecutors. Obviously, the ICTY participated in this and played an important role, so that experience cannot be fully replicated. But I do think that with the use of national and international experts, looking at an array of capacity issues and doing a proper assessment can be of immense value. I think that stands in contrast to some of the other experiences, particularly East Timor special panels where there was no assessment and little planning, which came out in our discussions at Green Tree. I do think, well, I think it's a promising model in the Bosnia State Court in terms of making a proper assessment. I do think it's also worth noting that these hybrid tribunals are really based on 2 assumptions. And I think the hybrid model will be valuable in domestic prosecutions. But one is the idea of credibility and trust, which is often lacking in the national system, and internationals can play a very important part in making institutions more trusted and having more credibility. I must say that I'm more skeptical on the other kind of branch of the use of international judges and prosecutors, and that is the idea of capacity building. First, because a good or perhaps a not so good judge or prosecutor does not mean that one is a good trainer or a teacher or even a good colleague. Moreover, there are deep language barriers in some places. The Bosnia State Court is one example. That's less problematic where there's a common language like English or French or perhaps Spanish, but there there are very significant differences of legal culture and approach that can lead to very thorny issues. And just on the capacity issues, I would just highlight the really 5 areas of assessment and strengthening that we identified through these green tree discussions. Strengthening the judiciary, strengthening court administration and registry services, and in particular witness protection, and facilities for witnesses generally, strengthening the prosecution to ensure that modern criminal law, international criminal law concepts like command responsibility, joint criminal enterprise, and also prioritization of cases was fully understood. Defense rights are in many countries not properly recognized, and the equality of arms is more in terms of words than deeds. So training on defense rights, and then strengthening the detention and imprisonment. One of the experiences that we've seen in a number of jurisdictions is the kind of go in the front door and walk out of the back door in prisons and detention units. As Steve Rapp commented this morning, I think one of the real difficulties in addressing these issues is getting the development agencies on side. It's those of us who work on international criminal justice are a fairly small group, and ultimately the resources are in development agencies, some at the UN like UNDP, but USAID, European development agencies, and that has been a real difficulty in getting them behind accountability efforts in a number of instances. I think that's it's easy to understand in the sense that they're in a country to build dams and to set up schools. Dealing with just issues of criminal accountability can very easily undermine those efforts, and therefore they frequently are not particularly, they're very difficult to engage on these issues. Even organizations like UNDP have a relationship with the national government. So these kind of capacity issues are very difficult to find the resources to address. I'm hopeful that with the adoption of Goal 16 of the Strategic Development Goals will be helpful in this, as this makes access to justice a priority and talks very seriously about justice and peace. So I will stop my critique there. And in conclusion, I would simply return to my opening theme that if complementarity is going to begin to deliver results, we have to deal with very serious questions. I think, as I said earlier, that I think too much lip service is paid to complementarity. Everybody likes it. We all like to talk about it. It's a little bit like the popular kid at school. But in terms of the reality, much hard work is needed, both on the political and on the technical level, neither of which is being adequately supported at the moment. So thus, if positive complementarity is to be something to victims and justice is to be delivered, then both domestic and international actors will need to address these questions much more seriously than they have. I'll stop there. Thank you.
Let me start by thanking Susanna and Juan and Bob for giving me the honor of participating in this excellent event. It is a great honor to comment on David's keynote address. But I hope you'll also understand my ambiguity about thanking you for making me go after him. It's a very difficult act to follow, and I hope all of you will understand. But I am very pleased that he decided to pick on complementarity as his topic, particularly because I think this is where the evolutions in international human rights law that we give the name of transitional justice and the evolution of international criminal justice that has resulted, among other things, in the Statute of Rome, have a lot to share. It's the conviction that there are some crimes that are so egregious that the conscience of humanity cannot abide their impunity. In my capacity as special rapporteur on torture, I will always insist that torture is one of those crimes. It's an international crime because of a treaty basis, the Convention Against Torture, but also because of the jus cogens nature of the prohibition of torture. But the obligation to investigate, prosecute, and punish torture is very well established in paper. It is so frequently violated in practice that my role as special rapporteur has to be to remind states that they have to investigate, prosecute, and punish every single instance of torture. And it's hard to do when states that do have the wherewithal, that do have the investigative power, that in fact, for example, put a stop to torture practiced by its own agents, are reluctant, like the United States, to investigate, prosecute, and punish the torture that we know has already happened. Under those circumstances, it's very hard to tell other states that they also have that obligation. Nevertheless, I think the international standard is very clear, and the concept of complementarity should give us a sense that the purpose of setting up international tribunals is not to take away from the domestic jurisdiction the ability to deal with that essential obligation, but a way of promoting and fostering that obligation and providing and sharing the tools in order to be able to do it the right way. This harmonious relationship between cases that are going to be brought before the ICC or other international tribunals because of the complementarity principle, but also with the use of universal jurisdiction possibilities of prosecution of those crimes, and especially the insistence that domestic jurisdictions have an obligation to conduct their own investigations and prosecutions and eventual punishment, is what I think is sometimes lost when we focus too much on international criminal justice, or too much on universal jurisdiction, or too much even in the domestic prosecution. And that's why I think the notion of positive complementarity that David mentioned sometimes might have been read by some as some sort of justice light, in the sense that we don't investigate and prosecute cases in Colombia, but we do share with them the insistence that they should prosecute them, and then years later there's no prosecution, either domestically or not enough prosecutions, let me put it that way, domestically or internationally. But nevertheless, I think the positive complementarity principle is very important, but we should also see as positive those situations in which the ICC prosecutes because of unwillingness or inability of a state to prosecute, because eventually it will be a positive complementarity if it helps change mentalities and attitudes in the domestic country, so that in the domestic jurisdiction, so that the civil society first and then the state itself does live up to its obligations eventually. I'm very grateful to David for mentioning the cases of Argentina and Chile, because as we speak, those are the countries where the largest efforts have been made, not only to prosecute, but also to tell the truth, to offer reparations, and to reform institutions, the four pillars of transitional justice as we see them today. We should also mention efforts in Peru and Guatemala, and civil society efforts in Brazil and Chile, in Uruguay, that should not be forgotten. It seems to me that the lesson that we learn from them is that political will is never automatically there. Political will is built with the appropriate conditions, certainly, and they're not always present, but the conditions are also constructed by the efforts of civil society, by the efforts of judges and prosecutors who take their job seriously, and ultimately, when society as a whole takes on the agenda of human rights and decides to really put an end to the history of human rights violations and to make nunca más a certainty and not just an aspiration. That also helps create the structural conditions for doing transitional justice, because we must never forget that it's not just about political will. If we try to prosecute without conditions of fair trial and due process, we're really making a disservice to human rights and to justice itself. So, but it is precisely the efforts of civil society and the diversified efforts, not insisting only on prosecutions, but also on truth-telling, on reparations, on institutional reform, and particularly through the participation of victims that we enhance through different mechanisms, that eventually creates not just the political will, but also the structural conditions, i.e. prosecutorial offices and magistrates and judges that have the wherewithal and the capabilities to do this. And here, international cooperation goes a long way. I will only mention that in the previous decade, we at ICTJ had the privilege of being able to facilitate an exchange between highly experienced investigators and prosecutors from the OTP in sharing their experiences with Argentine prosecutors, because system crimes are difficult to prosecute internationally, but they're also very difficult to prosecute domestically. And the experiences of the ICC, even novel as the institution was essential in creating the structural conditions for which that then allowed the prosecutors and judges in Argentina to have the really incredible result of having something like 600 people serving time, perpetrators serving time, of having another 500 or so awaiting trial, of about more than 300 having been either acquitted or their charges dropped, which shows that these were not sham trials in any way. And for the first time, even civilian accomplices of the atrocities of the military are being tried and prosecuted. The first conviction just happened this week in Argentina. So, and I want to just take up something that David mentioned about the debates between peace and justice, and how and democracy and justice too. I mean, it's the same familiar debate. Every time we're about to embark on a course of justice, there are always voices that say that's going to make peace much more difficult, or that's going to alter the circumstances of democracy, and therefore you're risking another coup d'etat and more human rights violations. We're all very familiar with those arguments that in the end seem to be based on the proposition that peace always trumps justice. And I should take that word back. Always should prevail over justice. What I mean by this is that we're going to need to confront that argument every time, and we should be able to confront it not only with the principles that victims deserve our efforts at justice, but also with a sense that there's political and moral arguments, and not only legal ones, why we need to investigate, prosecute, and punish, and tell the truth, and offer reparations, and reform institutions in order to put an end to legacies of very serious human rights abuses. And nowadays we have an argument that's similar to that about the need to sometimes to forget instead of remember. The book by David Reef about the bad uses of memory is, of course, well taken in the sense that we all know examples in which it's the clinging to certain interpretations of history that are considered collective memories that have really fueled wars and human rights violations. There's no doubt that that is a fact. On the other hand, any attempt to suppress memory would probably only play into the hands of those who interpret the facts the way they want to and for their evil ends. One needs only to be reminded of the infamous phrase by Hitler of who remembers the Armenian genocide. So if we don't insist on the memory of genocide, we only play into the hands of people who use history for their own ends. So, and I finish with this. Of course, memory is not the only reason why we must do justice. We must do justice for justice's sake. We can and we do make justice for the sake of long-standing and permanent peace. But we also should remember that that kind of peace is arrived at by memory, by making sure that we don't repeat the mistakes of the past, recent past or way past in the history. And in that sense, justice is not the way to impose a certain version of history, but it is a way of establishing a basis for the understanding of facts that is indisputable in the veracity of the facts established, and particularly that forbids us to use impermissible lies about what really happened. And in that sense, then, justice doesn't solve debates over history, and it shouldn't, but it does create the basis over which we can have a rational debate about how best to avoid human rights violations in the future. Thanks very much.
Thank you very much, David and Juan. We have 10 minutes for questions. We have a mic here. If you come forward, identify yourself and just try to make the question as brief as possible.
Thanks, Mohammed. It's good to see you. Can you hear me? Okay. It's good to see you again. And indeed, I specifically had you in mind in terms of the great work that you're doing, as Jack, and obviously others as well. I think in particular, just to underline the point, where there is no possibility of any particular justice mechanism, documentation is so critical, because there will be a day that I think you and I both recognize that there will be an accounting of some sort. Hopefully it's sooner rather than later. And also there's an accounting in history. Juan was talking about memory. And he and I both I think I can speak for both of us, vehemently disagree with the David Reef formulation that it's better to forget than to remember. I think there's an important politics around memory that's worth another conference. But the documentation that you're doing is very important. I do agree with you on the politics of the talk of genocide. One has to be very careful. If you're going to call something a genocide, you also need to make sure that you're not using it simply for political purpose. It's a legal term that gets used in political circles a great deal. So I think we should be careful about using it, and if we're using it, we should make sure that we're using it in a manner that don't have a single political purpose. So I would agree with you on that. I mean, I do think, and what I tried to do in my talk is emphasize that yes, I mean, I would be very concerned if the UN or the UN envoy is thinking about playing the amnesty card. But I do also think it's important to think in the medium and longer term as well. And I think one of the important elements of transitional justice is that there can be different approaches at different times. It's important that you don't take the possibility of justice, probability of justice off the table. But transitional justice does allow for measures of accountability to happen when there's a political opening for them. So I would be vehemently against either an amnesty or a camouflaged amnesty. But I don't think the first, as you said, I don't think the first step here is a hybrid tribunal or an ad hoc tribunal or something like that. I think that at this point in Syria, what you're doing in terms of documentation is really the most critical aspect. But I do think we can also start working with civil society groups, active social forces, and the diaspora and beyond to begin to build understanding of other experiences. And we've tried to do that in ICTJ. I think you were at least one of our meetings in Gaziantep and in Istanbul. And that's an important first step. So yes, let's don't take anything off the table, but let's use the possibilities that we have to prepare for the future through documentation, through much greater understanding. So thank you very much for your question.
Other question? Diane, did you have a question? Okay, I thought I saw a move. Okay. Well, please, go ahead. Christian, did you have a question? Yes, you can project.
They were supposed to be provocative, but Mhm. Is it on? Can you hear me? Or is it the other way? This way. Okay. My father was an engineer. I obviously did not get that gene. I don't think that the way I would look at it is that the Rome Statute is now in effect in 123 countries, and therefore the principles of the Rome Statute apply almost not universally. Some of them apply universally, and the Rome Statute applies widely. And that legal obligation, I think, is a tool to bring national prosecutions for accountability. It's a tool of accountability. So while there are a lot of problems, and I talked about a lot of the problems, I think we need to look at this on the longer term. I don't see the Rome Statute as a project for 5 years or 10 years. I see the Rome Statute as, something that's going to establish accountability over the long term. And I do think the legal obligations that states take on through the complementarity principle through the Rome Statute is valuable. What I'm disappointed at is I expect those states not necessarily to live up to their obligations. But I think is somewhat disappointing is that we've yet to build sufficient movement to provide both the political pressure and support, and I think the technical capacity is out there. There's a lot of experiences that have been discussed today that I think are really relevant. But the reason I've focused on the political dimension is I feel like we're, and it's hardly limited to complementarity. I mean, you look around the world and the human rights situation is dreadful. I think it's probably in the most difficult position that it has been in the last 20, 30 years. So we have to take that in context. But I think it is a useful frame to look at this and to try. You have the legal argument, so let's figure out how to use this complementarity principle to see more accountability, and that's only going to happen, I think, if we have a much stronger movement and states and civil society taking more responsibility. So that would be my point. Rather than, I wouldn't throw the baby out with the bathwater. I would press for stronger and firmer action by those who support accountability and those who belong to the Rome Statute to live up to some of their obligations.
Unfortunately, we've exhausted the time. We're on a very tight schedule today because of Rouge's lecture later today at ISIL. So I want to thank David and Juan for their presentations. We'll break now. The panel on complementarity and gender justice will be in this room. Building a credible and legitimate international justice system will be right across the way. Thank you very much.